The Department of Revenue brings these cases on behalf of the custodial party when there are minor children involved. When it's a court order, whether the parties sign an affidavit or the department jumps in or out, the court order stays in effect until there's another court order either suspending or terminating support, so that those charges continue charging even if the department is out of it for 10 years. So you can't just suspend a court order based on a letter from the Department of Revenue or an affidavit. So I think that's part of the misunderstanding here.
Well, I don't think it's a misunderstanding. I'm not arguing that, Ms. Campbell. I'm arguing that because the prerequisites to establishing an order were not met in 2004, meaning that there was no attachment of a child support guidelines, no attachment of financial affidavits by both parties, and there was no stipulation by the two parties, myself and Ms. Ball, or actually not even Ms. Ball, myself and the state, that we were not going to submit financial affidavits, which, by the way, those disclosures are mandatory. We all know, without me even getting to that thicket. And there's no time sharing agreement. So we have no competent substantial evidence, no time sharing agreement, no mandatory disclosures pursuant to 12.285, and there's no guideline worksheet attached. I'll rely on the rule, and I'll expect you to perform your duty and ask the judge to rule accordingly. Beyond that, the only issue is the $835.49. With that being said, I think we're pretty much finished. There's no, and by the way, there's no witness here to anything else, and Mrs. Britt has already admitted she doesn't even have any evidence to support the $835.49, so I couldn't even make a proper objection under 61.1354.
All right, Ms. Comrie, your response?
The department would end up proceeding with the fact that he owes the $835 and change towards that child. The department would still be seeking that amount of money. And the fact that Ms. Britt doesn't have the dates doesn't mean that there isn't evidence that the department can submit if we continue the hearing and submit it for his review, that the money is owed, how it came about, and why they're still going to proceed, even if Ms. Ball doesn't, want to proceed with her portion, because the department would still proceed with theirs and the money that's owed to them.
Just for clarity, and I want to make sure that the record is clear, is it Mrs. Comrie's position that she is offering information as evidence as a witness, or just in contravention of your responsibility as an officer of the court? Because if you don't have any evidence, you shouldn't be speaking to it.
Ms. Comrie, what's your position?
I don't hear her.
My position is that we don't have the information for today's hearing, but the department can get that.
I heard that the first time. I heard that the first time, Ms. Comrie. I asked you a specific question. Is it your position that you are offering testimony to evidence that you cannot support as an officer of the court? Or are you saying, Ms. Campbell, are you telling Ms. Campbell you want to move forward?
Records.
Ms.